disputes start piling up, they are able to resolve the disputes. The tribunal has also been piloting a devolution policy, meaning that we are taking the tribunal to the people, to the counties, to the devolved units. If we get an expanded membership of the tribunal, we should be able to hear disputes arising out of nomination matters in Nyanza, in Eldoret, in Kisumu, in Mombasa, without necessarily having everybody troop into the city to resolve election disputes. Lastly, we are looking at law reform. I have been talking about the law reform areas that we have been discussing. But one of the most important law reform areas that we have been keen on as a tribunal is to help political parties. This is not our main mandate, but it is our peripheral, it's our secondary mandate to help political parties strengthen their systems, their democratic systems. Remember, political parties' dispute resolution is part of the democratization process. So we are trying to strengthen the internal party mechanisms. What we have done, we have developed model rules for internal dispute resolution. We have been training party dispute resolution members and resources. We have been building capacity with our development partners just to ensure that political parties are able to resolve disputes at their own level. And as students, as members of the legal fraternity, we urge that you take an active role. Sit on these panels, build your capacity in dispute resolution. Again, you will see that the PPDT is anchored in the Political Parties Act. Only 3 sections of the Act refer to the Political Parties Dispute Tribunal. And yet, the work we do, the mandate we carry is a substantive mandate. One of the law reform areas we have suggested is that the Political Parties Dispute Tribunal be established by a standalone statute where the jurisdiction is clearly demarcated. Public understanding. When we started, people used to ask, what is this animal, PPDT? People were going to court with disputes which were reserved for PPDT. So public participation, we have made public aware of what we do, but we have a lot more to do in terms of reach out and publicizing what we do. Lastly, we publish a digest for lawyers on election dispute and the decisions we have made and the High Court has made on many of these areas. It's a digest of over 500 cases on all manner of issues in nominations. If there is any infraction of constitutions or party nomination rules, we have digested and put it down. For now, thank you very much, and back to you, organizers.
Thank you so much, Daktari. I know you've really had to compile and compound your presentation. And because of time, we will just limit ourselves to 5 questions. So those of you who have, we have agreed that because of time, we will have to pause the presentation by Dr. Kamala, and he has also agreed very graciously. The guys there at the other side, they have really put pressure on us. So because of that, 5 very quick questions. Who is ready? Yes, can start with him.
Thank you. First of all, my name is Richard Ondimo Watera, and I would like to thank you, Daktari, for your presentation. I must say that I've learned something today about the Political Parties Dispute Tribunal. Now, I only have one question. My question is in regards to the timelines. Is there a timeline by which political disputes must be submitted to the tribunal prior to the elections so that you don't have the backlog of cases that you've been experiencing? That's my question. Thank you.
Yes, Mr. Mwaniki.
Thank you, Dr. Very quickly, what is the fate of this politician who loses their case at your tribunal? Then you have told us that they can now go to the High Court. I don't know, it's by way of appeal or by way of JR, whatever approach. But in the meantime, the general election has been conducted. And this person wasn't a candidate. Now, in the High Court, this person succeeds. The High Court says the tribunal was wrong. So what is the fate of this politician? Because he or she has now been shut out of the general election. Where are we? Where are we on this? Thank you.
If there are no other questions, Dr. you can respond.
Good. Two questions. I will start with you as Richard. What timelines before the election does a party have to submit? Now, laws on general limitation of actions apply to this tribunal like it applies to any tribunal and court. However, the period for disposal of the dispute is 90 days, 3 months. So the tribunal must hear and determine a matter within 3 months. Usually, the difficulty that comes post primaries is that there is a floodgate open. There's a flood of cases from all over the country for all levels of elections. And usually, the way our political parties are structured is that you have seen the IEBC timetable for elections published the other day. And there is a deadline within which the nomination, the actual registration of nominees. The registration of nominees is what used to be called the returning of nomination papers, when the candidate has to take papers, after which there will be no other candidates accepted. Now, what the challenge we have faced is that every political party wants to conduct their nominations on the very last day or the last 2 days. When I sought explanation from the political parties caucus, I was told that it is an effort to try and avoid a political party infiltrating the other's nomination, so that we don't have proper political party registers in this country. And that is one of the things we want to straighten out in the new law. What usually happens is that people will generally vote in the ODM nominations, vote in the WIPA nominations, the same people. In the UDA nominations, the same people. Because parties do not maintain a proper party register. I'm sure some of you have seen situations where when you check your name and the political register of political parties, you find your name registered to a party you don't even know exists. So the position here is that when disputes now come to us, all the matters are so urgent because in the next 2 weeks, disputes must be resolved and nomination papers must be returned. Now, that makes the tribunal's job difficult because the tribunal has to make a determination on the spot and allow that party an opportunity to even appeal and a second appeal. Now, that takes me to the question by Mwalimu at the back. Now, Mwalimu, if you lose in the tribunal, you have a right of appeal. It's an automatic right. If you go to the High Court and the High Court sets aside the decision of the tribunal and perhaps hands you the nomination certificate or asks that the nomination be conducted afresh, if the nomination process and the election has not been completed, it's straightforward. The court will issue orders, whether they are in judicial review or even in a constitutional petition, I have seen that, or a normal appeal, because the Act speaks about a right of appeal. Some people take it through judicial review, and courts have said that is still possible, but you narrow. When you go by judicial review, you are now narrowing the scope of your complaint. Now, many complaints were not completed or determined by the High Court because of time constraints. In fact, one of the difficulties we have been having, and this is a discussion we have with the IEBC, is that sometimes the tribunal was making orders when the IEBC has begun printing the ballot papers, for instance, or publishing the gazette notice of the people who are to appear on the ballot papers. Now, it is a cultural thing. The IEBC has attempted to give a timetable that would accommodate dispute resolution for 1 month, but I know for a fact, as sure as day comes after night, that political parties will hold nominations on the last day. What happens if you win in the High Court after the elections? Now, your course of action may have been overtaken by events, but the law as it stands today is that any dispute post-election is a matter for an election petition. If you can carry that into an election petition as a petitioner, because remember, you don't even need to have been a candidate to file an election petition. All you need to is to have been a voter. You can still use that decision or that evidence as a basis for an election petition. We have been grappling with another concern at the tribunal. What happens when somebody agrees with another? Mutubwa agrees with Dr. Komolo that let's withdraw this matter from the tribunal. I will refund you the money that you used in the campaign. Allow me to go into the main election. And when we succeed, we will appoint you an ambassador. Those are arrangements which people always have. And after the election, one of two things happens. The party does not win, and therefore they cannot nominate you as an ambassador. Or the party wins, and you are no longer useful to the party as an ambassador. Does that person have a cause of action if that consent was recorded before the tribunal? I will not tell you what my views are. I have a view, some other people have other views. How do you enforce consents between political parties, even as we encourage parties to resolve disputes amicably? The resolution that usually comes to the tribunal sometimes is that so-and-so steps down for the other in consideration for something else. And they say the government is big, we will accommodate you. After the election, is that agreement enforceable? If I said I will refund you 7 million you used to mount the nomination up to the nomination level, is it something that can be enforced by one of the aggrieved parties? Thank you very much.
Thank you very much, Dr. Mtuba, and I like the way you have balanced the paper between you as an arbitrator, you as a teacher of the law, and again now you exercise jurisdiction as a member of the political parties tribunal. Congratulations. And I always like his engagement. One time I was doing a course in arbitration, and having consulted him, I actually qualified. And let me say, I'm forever grateful for that, because he did us coaching and you are doing well. These students you see equally look up to you. I hope that your paper is going to be shared so that they can increase the wisdom, because they're going to be your research assistants. I'm sure the tribunal needs some serious research assistants. So you can see jobs are already opening up. Ensure that you take a photo when you leave here, just in case you go for interviews. Now, I will invite our Assistant Director, Isaac Loba, to gift. We have a present, which equally you can declare it is less than 20,000, because you are sitting at the Political Parties Tribunal, so that you can present this gift to our guest. Then we have agreed by consent that Dr. Kamala will speak in the afternoon, together with Kaute, who is right at the back, and our friend who has come. They will be presenting this afternoon. So we want to have a consensus that we are taking a lunch hour break at this time. Please go out there. There's going to be a card. You pick that card. The lunch is strictly 45 minutes. So what's the time now, Dr. Komolo? We should be back here at 45 minutes. So that we... Did you want to say something? Okay. So thank you very much for that. Let's break for lunch. Please pick your meal card as we go. Dr. Kamala is going to speak in the afternoon. We have already agreed in the afternoon. All right. Thank you very much. Those who are outside, please try to.
All right. Thank you, Bwana Mgindia. So our next speaker shall be Dr. Charles Kamala. He's a lecturer at the African Nazarene University. His specialization is in international criminal law. He has a PhD from UPPA, France. I'll not try and pronounce that name. An LLM from University of London, LLB from University of Nairobi, postgraduate diploma from Kenya School of Law. He's an advocate of the High Court. He's also list counsel for the ICC, the African Court of Human and People's Rights, as well as the United Nations International RM on Criminal Tribunals. So he will be making a presentation on electoral justice through public participation in Kenya's Building Bridges initiative. Karibu, Daktari.
Ladies and gentlemen, thank you very much, Wakili Wakimani. I do have a PowerPoint which I need a moment or two to assemble. So with your indulgence, I'll try and liaise with the IT people just for half a minute before I get started. Or maybe while they do it, I can give a background more than what has been explained about my interest in electoral law and why I am conversing on this matter. Yes, my doctorate was from the University of Po. Po is where Professor Thibault is a professor. That's in the south of France. Before that, I was, I don't know whether you're doing pupillage now. Many of you are still doing pupillage. There's an advocate by the name Feroz Noroji. Have you heard of him? Feroz was my pupil master. So when I was doing pupillage, one of the things we did was, at that time, the new Attorney General, Amos Wako, called for the new multi-party elections, and he gave notice of 7 days. It was 7th December or something like that. And he argued sorry, small break.
I can see our online audience, they are trying to join. Just give us a few minutes. We are trying to bring the PowerPoint there. I also know that we have a presenter who was also joining us online. He will be patient. Someone is going to conduct them at the right time so that once Dr. finishes, then the online speaker can come in. Let's try as speakers also to manage the time.
Yes, thank you, Wakili Wakimani. As I was saying, so that was at that time, we were able to persuade the court, and Judge Baluto was transferred to Kisii court because he agreed with us that the Constitution clearly says you have to call an election in not less than 21 days. You can't call a snap election, which was the secret weapon at that time. Fast forward, obviously, there's the petition against, well, there was another petition which complained against the fact that President Moi was standing again, yet he had served more than 2 terms, and we said that the maximum was 2 terms only. So James Orengo brought that petition in against that same election in 1992. There was President Kibaki's petition where we were stopped from petitioning. There were so many grounds of petition, but unfortunately we couldn't serve the respondent in person. You're supposed to get past his security detail and serve him in person if you want to be heard. Long story short, technicalities. Technicality of not being able to be heard because of failure to serve. Those are using technical procedural rules. So by 2007, what happened is the country had lost confidence in election petitions as a mode of expressing grievances. You saw the conflict. And then we have the new constitution with us. So the first observation about the new constitution is that we are trying to get away from procedural technicalities so that we can transform from command governance to democratic governance. That's the whole transition. When you talk of transition, this is a transformative constitution. Transformative from where to where? From command governance to democratic governance. The question now becomes is, to what extent do our electoral laws facilitate our transition to command governance? And my hypothesis, my argument here is that, lo and behold, the politicians are not interested in transition, so that the technical legal rules still remain. The politicians have a vested interest in retaining office. If you ask me to make rules about a competition that's going to remove me from office, I'll not make them. I'll make skewed and biased rules. That is the opening observation, and that's the problem that we have. Next slide, please. If you can. So that's the problem. Politicians are conflicted in the making of electoral rules. So when you hear, we are people of integrity, we are working in the best interest of our constituents to get us out of office, you think again. I'll prove to you that that's false. It's a false assumption. And therefore, the conclusion of the paper is, unless the making of electoral laws is done through public participation, you are going to get biased and skewed electoral laws. And it stands to reason, and more importantly, there is evidence of that. Of all the laws which Parliament is dealing with and the Senate is dealing with, that you are told in the morning, you are not told that there is a public participation bill which has been on the floor of Parliament since 2016. It obviously died a natural death. 2019, it has been republished and it is not being discussed. There is a reason for that. Worse still, that bill does not even include political rights. So what Parliament is saying is that Kenyans are capable of participating when you are making primary rules to do with roads, marriage, taxation. But when it comes to enacting laws which deal with transfer of power, electoral laws and referendum laws, Kenyans are not involved. And ladies and gentlemen, that is the reason why there are conflicts in this country. That's the reason why there were conflicts in 2007, 2008. That is the reason why there were protests and national resistance movement of Kenya in 2017. It's because of a dissatisfaction of the kind of electoral rules that we have. And that's what the paper explains. It's due to the theories on human nature. I'll try and ground it in theory so that it doesn't sound like this is my own invention. I'll talk about Hobbes and Locke and others. I'll explain that Kenya has a procedural democracy. It is a procedural democracy, and that's what it is based on. And that procedural democracy cannot transform Kenya into the governance system, into a governance system that produces good laws, increasing social welfare, and that system basically perpetuates incumbents. That's what was used to perpetuate incumbents throughout the return, since the return to multipartyism. And it's abetted by state capture. Next slide, please. I'll explain all those terms. So obviously, civil society were aggrieved by that after observing that in 2013 there were problems with the election. In 2017, civil society challenged the IEBC's management. You heard a lot about election management, and all the management rules are there. The election management rules are rules that say that the chairman of the IEBC can alter declarations from polling stations. So civil society challenged that successfully at the Court of Appeal, and it was upheld, and that's why the presidential election was petitioned. Next slide, please. And obviously the government, the incumbent repressed protests against what was perceived as a rigged election, and there were crackdowns before a people's president was sworn in. So finally, my solution or my proposal is that our democracy should move from liberal democracy, and I'll explain what that is. Constitutional democracy is not good enough. Constitutional democracy is what supported the Kiai case. I'll explain the Kiai case. It was inadequate to cure the tensions and the conflicts and the social upheaval. So we must move away from both. Both are variants of liberal democracy, and move to deliberative democracy. Deliberative democracy is a different system, and it will be explained. It promotes equality over liberty, and the problem, again, is the fact that politicians are self-interested and don't expect better. Next slide, please. So that's the point I was making. We haven't enacted the public participation bill. Thanks. Parliament has not enacted it, and I'll distinguish between, there has been had this debate about when an election starts. I'll be making a strict distinction between election period and the period in between elections. And this lecture is not concerned, or this paper is not concerned with the period in between elections. I'm concerned about the election period. Do you know when election starts? When IEBC calls the election, that's when the election starts. Okay, but there is a strict distinction, and that will tell us that we are concerned with the making of electoral laws. I'll define electoral laws, and I'll explain that they are distinct from other laws about that govern our society and our behavior. And we are concerned about electoral laws. How do you do it? So, if we begin, it will sound like a slight repetition at the very beginning, but it will get us grounded. So, Kenya's parliament, this one is on introduction, that was not on me. No, that one is set. Yeah, now move to the next one. Sorry about that, technology. We'll talk about the server. No, yeah, okay, that's it. So, buildings, bridges should provide for citizen participation in the making of electoral laws, and obviously referendum laws. This one is changed, and that one hasn't changed. Sorry about that. No, that one changes. No, just make it change. Make it change. So they want me to see this, but not you. They want to see the same thing. Okay, thanks. Okay, excellent. So, yeah, thanks. So, democratic transition depends on deliberative democracy. and I'll explain what the deliberative democracy is. We want to abandon the liberal model, and the liberal model is basically based on economics, and it assumes that everybody is self-interested and fearful. Constitutional democracy is better than formal democracy because the courts protect human rights, and the constitution is progressive. Next one, please. Yes, again, repetition. The KI case and the Odinga case were successful, and a little recap on what I had already said. If you have any questions and it's not elaborate enough, please do tell me at question time. Next, please. The question we're asking is whether the public participation bill will remove electoral violence in Kenya, and I'll explain that it can and how it can do that. It must facilitate people's involvement in the making of on political rights. And like I've said, political rights are omitted from that bill. The golden handshake is an attempt at deliberative democracy. What the golden handshake does is it suggests to you that if you want leaders, one way of getting your leaders is by choosing them. You choose your preferences. Another way is we can simply agree. We can see, Wakimani here is very organized and he can provide a service for us, and no one is, disputing it. And provided you are comfortable with that, you can deliberate and explain his merits. He's the only pilot in the room, and we want to fly a plane. Why should it be another popular person? Let him fly the plane. So we can debate with each other, dialogue with each other, and that's what deliberative democracy is based on. The handshake wasn't sufficiently deliberative, but as you can see, the courts are demanding for more public participation and more deliberation. Next. So we'll briefly go through what procedural democracy is and distinguish it from constitutional democracy so that we have a background from where we are coming and what's wrong with the current system as it is. We'll move very quickly through the 2017 presidential election. I'll simply explain the basis upon which the Supreme Court rejected the declaration of IEBC of the president's first round victory. We heard a lot of tests yesterday. I'll try and zero in on what test was decisive. And I'll distinguish second order deliberation from first order. First order deliberation is basically about everyday life. What rules should govern our everyday life? Second order deliberation is about governance. And I'll explain that. And then finally, we'll turn to public participation, which is in the Constitution. I'll explain that it's not in the public participation bill and it should be there. And that is what is creating tensions in our society. Next one, please. So this is just background, and I'll say it quite quickly. We can ask questions about it afterwards. Disagreement is part of life. You can't talk of governance unless you have disagreement. Just like you can't talk of thought unless there is truth. You can't talk of institutions unless there is justice. You can't talk of property unless there's scarcity. So long story short, disagreements, unless you're angels, where we all see things the same way, people are going to disagree about the distribution of public goods. You need groups of people to make public goods, but everyone will say our priority is this, our priority is that. And unless we want to engage in those disagreements to become conflictual, we must establish what is called a rule of authority. How do we decide who is right and who is wrong? What the truth is? That rule authority is called an election. It's a secondary rule that tells you how you are now going to distribute primary goods. And other secondary rules are rules of adjudication, rules of modification. Modification is parliament. Parliament changes the law. Adjudication is the judiciary. It decides disputes. Enforcement is the executive. It enforces the rules. Rules of obligation are the ones that bind you and me as ordinary citizens what to do. But the mother of all this governance is the rule of authority, because it gives government the mandate to do what it does. And by agreeing, in a democracy, you agree on the rule of authority, and the rule of authority is one man, one vote. That principle is central to it, and that all of us are equal and reasonable. So if all people are equal and reasonable, and equality is a higher value than liberty, what happens is we agree on one man, one vote, and you get first past the post. Stated in that manner, next slide please, it's innocuous. But because of ethnicity, as you were told by speakers in the morning, like the senator, in some communities, all you need to persuade is one person and you've got the whole community. Supposing I'm from a minority community, what it means is that minorities can never govern in Kenya. I mean, it results in that. Procedural democracy is problematic in Kenya simply for that reason. I think I've gone through all this. Next slide, please. So, put in crude terms, we purchase the policies that we get through votes. So, your votes as constituents, get your MP will give you the policy, and the theory is that that policy is demanded by the majority of us, so that's the best policy. You get what you choose. If there were no tyranny of numbers, it would work. In other words, if there was a possibility that you could persuade other people to change their vote because they are people who are not voting purely on ethnic lines, what you would get is a situation where this election I am a minority, but I'm content to be a minority and I will not engage in civil disobedience because I can wait for the next election. What was happening in Kenya's last parliament was called a tyranny of numbers, where the minority knew that it couldn't get anything and it could get bad policies. That's what happens in one-party states. And the only response to that is civil disobedience. You can be a conscientious objector, but ultimately that's when you start getting tensions, you get post-election violence, and you get social instability. Minorities have a legitimate reason to reject procedural democracy altogether. Next slide, please. So when you add state capture to that, state capture is the phenomenon where within a majority, factions emerge. And those factions say they want to perpetuate themselves forever, so they don't even conduct, the procedures are distorted. Africa has perfected what is called legality without legitimacy. We have a charade of an election that makes it look like the legality has been performed formally, but legitimacy, there are some countries where you can find, a minority leader with minority support, but they are appearing as if they are winning the election. I won't split hairs about the Kenyan position, but that state capture frustrates deep democracy. The Hobbesian state, the only thing I'll say about that is that Hobbes thought of having a very powerful state, a powerful executive as the cure of all our problems. And he doesn't take sufficiently into account the fact that the state itself can be tyrannical, but absolute power is basically part of the problem. You will start getting the deep state and state capture. Next slide, please. So, can constitutional democracy cure the problems of formal proceduralism, technical rules? To the extent that liberal democracy is based on Locke, constitutional democracy is based on John Locke's departure points. Not that we are a war of all against all without the state, but we start from a Garden of Eden. All we need to do is to protect private property and want to enforce contracts and raise taxes, collect taxes. And to collect taxes, you need a state. Locke's state is weaker than Hobbes' state. So the outcome is that there are limits on state power and courts can review the executive overreach through judicial review. My conclusion about that is that, next slide please. Nonetheless, Claude Ake has criticized it that it's based on privilege in property and it privileges property over equality. But even though the courts protect against certain moral fundamental rights from being violated, it doesn't go far enough. It still privileges the ruling elite. I dare say judges are part of the ruling elite. So they share the same ideology as the ruling elite. Instead of simply saying that, ask yourself, when you have a situation where we'll do that with looking at the elusive, why electoral justice has been elusive in Kenya, to show that there are still technical rules which hobble the emergence of electoral justice. And this part, I think, will be, I hope, the easiest part. I'll try to get through it quickly because I like to think you have all read the cases we are talking about, so I don't have to give a lot of the factual background. The IEBC was centralized. Here I quote Sihanya, you can see his name there. He wrote an article immediately after the 2017 election, which basically explained that IEBC, because of the amendments to the Electoral Act or the electoral law at that time, the IEBC chairman lost his power to alter declarations which were made at polling stations. He became administrative and ceremonial. When you receive the results, you just declare them. And that there are various articles of the Constitution which were discussed, and I discussed them in the paper. But the take-home point about KI's case is that these were citizens telling the politicians that the electoral laws are skewed and you can't get free and fair elections under the arrangement that you have. Many laws, Electoral Act from 2011 and so on, Political Parties Act, but we're not getting electoral justice. And the Court of Appeal agreed. And IEBC chairman cannot change polling stations, returning officers. He must simply declare. If there's a problem, it will be decided by an electoral court. What the Supreme Court held in the Odinga case, it was simply by admission and by deduction. Wafula Chebukati, the chairman of IEBC Commission, admitted that on 11th August, he did not have 11,000 of the 40,000 polling station forms, Form 34As, with him. It's on, NASA asked him for them. Can we see these forms for 34A? And his answer to their letter, I don't have them. Those letters, Form 34A, only surfaced on 18th August. So he announced the poll results in the absence of the primary documents, which the law requires him to declare those results based on. So it's impossible for him to have declared any results, and that's why they were correct, in my view, to conclude this is not clear, verifiable, transparent election. There are other aspects of, there was a spurious 54-44% margin maintained by the server. The IEBC refused to disclose the information in the server, and those points are made. Next slide, please. The outcome was that a rerun was to be held in 60 days. The opposition candidates declined to go for the rerun under the same IEBC with the same rules. In the meantime, the ruling party started amending the Election Act. It started saying things like the vice chairman of the commission will be the one to announce the result. The quorum in the IEBC can only be 3, and so on. Those kind of amendments were subsequent. Maybe they're on the slide after this, but NASA morphed into the National Resistance Movement and began to protest, and 100 people were killed, Baby Pendo being one of them, and it was declared treasonous. Nonetheless, the people's president was sworn in at Uhuru Park on 30th of January, and 2 months later there was a reconciliation under a memorandum of understanding, which nobody knows up to today. So that history is being captured to show that constitutional democracy was not sufficient to introduce peace and remove the tensions. So, and what NASA was engaging in, where they were asking for deliberations, the irreducible minimum. We want to discuss the rules about who holds IEBC position. It shouldn't be Wafula Chebukati. How the results are declared. Should it be the real-time transmission of data from returning officers, polling stations? Those are rules about what we call second-order rules. To repeat what I had said earlier, first-order rules are rules about everyday life, and we're not concerned with those in this discussion. Parliament, whenever you see an advert in the newspapers calling for public participation, it's for those innocuous ones. Because once you already hold power, needless to say, whatever public participation you give to the citizens can be limited because you are debating the final bill in Parliament, and it's hard for anyone to protest. You can allow public participation. We are concerned with second-order rules. These are rules about transfer of power. And deliberative democracy is based on discussion, deliberation, debate, and consensus. Basically, what it says is in Africa, because in some, take Zimbabwe, Shona are 20%. Sorry, Shona are 80%. Dembele are 20%. If you have elections and first past the post, Shona will always be the president and Dembele will never get their opportunity. But if we believe in good faith that we can cooperate and we want the most talent in the society to emerge, they can agree on rotational president, power sharing, proportionate representation, and that is the faith of deliberative democracy. And the paper asserts that that is different from simply depending on the result of election day, which is leading to rigging and other things. Next slide, please. So the Public Participation Bill creates regulative authorities and guidelines which can assist citizens to function as in deliberations. We'll come to that towards the end as a conclusion. Second order deliberations are about officials and citizens' behavior during referendums or elections. And yes, I'm getting a speeding warning. Perhaps it's because of the repetition. In front of you are what the electoral laws are. Electoral laws are laws about delimitation of boundaries, registration of voters, registration of political parties, buying the ballot boxes and apparatus, advertising, election expenditure, campaigning, returning officers, presiding officers, until election petitions, and obviously the ramifications. It is that conduct which electoral laws regulate. Next slide, please. This is the assumption that I'm inviting this distinguished audience to abandon. In English law, they say public officers can do no wrong. After all, you elected me. I'm acting in your best interests. Assume that I'm going to work in your favor. Do elected officials act in your best interests when making electoral law, in which they are self-interested? I argue that they are not people of integrity, and it's a bit deeper than simply making that statement. And not only do they not select the best primary rules of production and consumption, but they refuse to vacate office. Now, I don't want to explain what has been happening during single-party Kenya, but in 2007, that was the argument, and subsequently. So, to cure that, you and me must get involved in the making of electoral law in order to avoid biased electoral laws, which then give you biased officials who will now start the problem of corruption and applying public property in their interests. and so on. Now, the final section of the paper. I've already mentioned that Justice Chacha Mwita declared the amendments to the Elections Act as unconstitutional and undemocratic. These were made before the rerun on 26th of October 2017. But again, that's another indicator that shows, were those rules made in your constituents' interests? So what are political rights? The right to form political parties, the right to contest elections, and the right to have regular and free and fair elections. In front of you now, you have the Political Parties Bill of 2019. This is the preamble. This is the purpose of that bill. To provide a general framework for effective public participation, that is correct. To give effect to the constitutional principles of democracy and participation of the people under, look at the articles which are there. 1, which is the preamble. 10, which is the national values. 35, which is the right to information. Conspicuously missing is Article 38. So there are no political rights. Then you jump to land and environment, 69, 118, 174, and so on and so forth. But my point here is why, although we purport to be saying that we want public participation, here is where I get the evidence that it's not for second order or political rights, it's only for primary rights. Here's the rest of the bill. I look at the whole bill and its narrow scope. You cannot be given public participation if the request is unreasonable in the circumstances or if you do not agree to keep the information confidential. There's simply some narrowing of it. But suffice to say, why is the bill being delayed and why is its scope narrow? Public participation can facilitate transformation, but when people are excluded, I'm already at towards the end, they feel a sense of indignation. Why should you, if we are all equal, why should I take decisions on your behalf for you? You feel humiliated about that. I make that point. It's a problem with the structure of which excludes some of the country from making some of the rules. So I only have 2 sections to go. Can we have a different concept of human nature? A concept of human nature which says instead of being self-interested, we are interested in our fellow Kenyans, our fellow human beings. I try to suggest that that is possible, and that has to happen in Kenya for Kenya to move forward. We have to, in as much as people can be self-interested, we can be cooperative, so that people won't be free riders. It's obviously there's a tendency for people to free ride and let other people fight corruption to benefit from the fight against corruption. Let other people change the law, but this is a call to all people to cooperate in the debate so that you don't have high impunity. I think I must have skipped the slide where, oh, I haven't been telling you to skip here. Sorry, ladies and gentlemen, I've been proceeding without you. I wanted to basically say that it's not only in the Kenyan constitution. Carry on. Next slide again. Next slide. Carry on. I was speaking to all those, I thought they were changing. Carry on. You seem to be, yes, next slide. You seem to be caught in a loop. Eh? You're going backwards. I don't know what's happening. You're going backwards. Yes, you're going backwards. Go forward. It's a machine. Sorry, technology. Ladies and gentlemen, the point I was coming to the last slide, but I wanted to explain that the African Charter on Human Rights, Article 20, is on the right to participate. It's on the right to self-determination. The right to self-determination, which gave the colonization declaration, is in the African Charter, Article 20, and it gives you the right to participate. In the UN Declaration on Human Rights, the right to take part in national affairs of governance. Yeah, they seem to be caught in a loop of some kind. There's some problem with technology. Anyway, so look at Article 20 of the African Charter, look at Article 21 of the UN Declaration on Human Rights, look at Article 25 of the International Covenant on Civil and Political Rights. All of them entitled us to free and fair elections, universal suffrage, governance by the will of the people, one man, one vote. So it's not unique to us. The demand that we are making is universal. Questions about postponing an election, it can become an international problem. It's not exclusive to Kenya alone. I conclude the paper by saying we've had times in our history when we have relied on cooperation and consensus. This is not the first time. Immediately after independence, you know very well that Jaramogi Oginga Odinga, who was the doyen of opposition politics in Kenya, agreed, refused to take power unless Jomo Kenyatta was released from detention and prison first. Kadu closed the floor to join KANU as a matter of consensus and to have unity. So I simply explain that there can be win-win situations. The problem with procedural democracy is that it is based on win-lose and exclusion, and that it concentrates on the, according to my sister Koki, who was looking at the last an election cycle, the last 3 parts of an election. What happens on election day? Voting, balloting, and tallying. But elections are more important than that. They concern campaigning and sensitizing people, and that ordinary Wanjiku can be involved in debate about controversial matters, whether it is death penalty, whether it is affirmative action, whether it is abortion, whether it is the democratic system. I make that point, that is possible. And we have to be pragmatic at this time, and pragmatic, the handshake is based on that pragmatism, that we are fighting elections, we are involved in perpetual elections from election time to election time. We're never getting involved in development. People are dying in the country. There's tension. You can't get investment. So the pragmatic thing to do was the peace handshake. And my conclusion is how to do that. Obviously, you have to have people's assemblies so that people can participate. That happens through county assemblies. But, and this is important, the state has to support social institutions. The state has to support social institutions, and that should be done because the right to vote is not a first-generation human right. It's a second-generation human right. It's a human right which you can't enjoy on your own. State expenditure is necessary to enjoy it. So it's enjoyed as a group. Sorry about the problem with technology that they seem to have been having. I had wanted them to control the elections, but I conclude that what we have at the moment is called electoral dictatorship. You go through elections, but it's still a dictatorship, and the way to move away from that is through public participation in the making of electoral law, and the rest is in the paper, which I have here, and I'll be willing to take questions on it. Thank you for your indulgence and your patience, Mr. Wakimani, and I was planning to say that in the morning, and thank you for staying until this hour.
All right, thank you, Daktari. 1,000 apologies for the technology there, but I'm sure we'll be able to go through the paper. So essentially, a move away from constitutional democracy, procedural democracy, and to embrace deliberative democracy. Thank you very much. What we shall do is we shall have the next speaker. So hold your questions, and then we'll have one session where all the questions will be taken down and answered by the presenters. So our next speaker is Fad Mayomba, and Fad is a lawyer by profession. He graduated from his master's LLM and bachelor's of laws at BAM University in India. He's a certified professional mediator, currently attached to FIDA. Before joining academia, he served refugees at Kituo cha Sheria. It is at Kituo cha Sheria that he developed a passion for human rights, refugees, and other persons of concern. He recently secured admission to pursue PhD in law at the University of Pretoria, South Africa. The doctoral research explores local integration as a viable, durable solution for refugees in Kenya. And he's currently engaged as a lecturer at Mount Kenya University Parklands Law Campus, teaching alternative dispute resolution, forced migration, international refugee law, and criminology and penology. So he's going to present a paper titled Right to Vote vis-a-vis Right to Life, an appraisal of the 2022 general election preparedness. And he has promised to take strictly 10 minutes. So welcome, Mr. Mayomba.
Thank you very much. Yeah, from the experience of my former presenter, I'll opt to use my presentation slides so that I can take control of the same. Okay, great. My paper is titled The Right to Vote vis-a-vis the Right to Life. This is in particular in consideration to the COVID pandemic we are currently experiencing in Kenya, and thereafter probably look at some one or two case studies. How do we rate in terms of importance between the right to life, good health, vis-a-vis political interest in this country? First, I will wish to quote Article 38(1) of the Constitution of Kenya, which makes it a right for every person to make a free political choice for his own political leaders. 2, Article 38(2), the right to free, fair, and regular elections, keeping in mind that the general election this year is scheduled on 9th of August. Unfortunately, 2 years ago, we got to experience the COVID, now pandemic. And of course, the world was affected, and so were we. My interest, however, is on the response Kenya chose to take, and I think I'll want to remind ourselves, particularly on the clips we watched on TV in Mombasa, where we saw Kenyans being beaten like what people could say burukenge at the coast, just because of what the government believed was the need to socially distance people. Fast forward today, we are not seeing that. Why? Because it's my belief that when we weigh between the lives of citizens and the interests of politicians, there is a gap, and that is the gap we want to realize. Elections are quite complex. I've had a privilege to manage an election previously, and I know the processes and what it takes, from sensitization of the public, which require a lot of crowd pulling and a lot of engagement with the public. However, thanks to COVID, we now have a different experience during our election period. For example, IBC itself has confessed to a very poor turnout in terms of registration of potential voters in the upcoming election. Of course, we foresee a challenge in terms of managing crowds. I do not think there is a politician who does not love crowds. And as a result of this, there is always a will of the government to bend backwards, at least to accommodate as many people as possible to attend the rallies. Of course, throwing to the wind the COVID-19 precautionary measures put by the government themselves. Apart from registration, campaign, we are witnessing a lot of overcrowding, of course, without care of, the COVID. I foresee a bigger challenge when it will come to the voting day, because voting day in Kenya is a big event. I even believe it's a public holiday. That's how serious it is in our republic. And so the queues, if you've ever voted, you realize that the queues are long and uncontrollable. And I'm sure no politician will want to tell people to keep social distance, at least on that day. At least in Kenya, currently, transmission of results is done virtually, and we'll be expecting appeals and swearing in ceremony, which obviously will be very, very crowded. Let's look at the right to life. Article 43(1) provides the right to every citizen to the highest attainable standards of health, which includes, of course, healthcare services. It's no secret that during at the peak of, this slide may not be similar to what you are seeing, so don't mind about it. At the peak of the wave 1, wave 2, wave 3, government was unable to contain the numbers for good reasons. No country could. And as a result, the government was unable to take care, at least the health functions for the people. And for that reason, they recommended people from weeping, they were now recommending people to what they were calling self-isolate at home. Why? Because government did not have the capacity. I remember there was a time some company volunteered to provide oxygen to government, which in normal government, it's very embarrassing. But because Kenya is God's own country, we take it as a good gift. I want to take you through just data I collected 2 days ago. I was watching Citizen TV, and this is what I gathered. At the end of the first registration, IBC had gathered 1.4 million against 6 million of the originally targeted population, which is merely at 23%. Remember, the costs included, meaning when the IBC seeks funds, they seek the fund based on the numbers of people they project. So if they are projecting for a registration of 6 million, then the budget is worth the cost. But then how many people are registering? 23%. As of 17th of January, as of, I believe, the second registration target, which is ongoing currently, the data are also not encouraging. Out of the 1.4 million persons expected, only 229,000 had registered. It's even get worse in the diaspora. In Juba, South Sudan, only 25 persons had registered. In Washington, D.C., only 31 persons had registered. Kigali, Rwanda, only 22, and Kampala, only 16. You can imagine the millions invested in that process. I want to conclude with some way forward and a little experience sharing of a very successful country in terms of electronic voting. There is, in India, we have what we call electronic voter machines. India got rid of ballot paper some years ago. So how do they do their processes? Their last general election, which was conducted on 11th April 2019 to 19th of May 2019, it had over 912 million voters. You can imagine, 912 million eligible voters. How was the process conducted? In India, all you need to do is just press a button. You press a button and your vote is cast. I was just curious, is that possible in Kenya? Can our politicians accept such a process where you go, click a button, and will even the Kenyans accept such a process? Probably we may need to consider social media campaigns. I know in campuses, elections these days, the rules changed from the usual one man, one vote to representative voting, which is what I will be recommending. That probably it's time Kenya goes for digital voting and representative voting, whereby, as my former presenter said, we don't all have to vote. We probably need to entrust our right to vote on a few representatives, which I know can be quite controversial. And finally, we probably need to push our politicians to end the doublespeak, because when politicians and government tells us keep social distance and do all those manner of things, we all know they don't follow the rules. Thank you and bye.
Thank you very much, Mr. Mayomba. Very brief and very concise. So what we shall do, we shall take 3 questions each for each presenter, and then we'll move to the next session. So questions, we have 1, 2, 3, and then we come back and deal with these ones. Let's hear the questions. We've said 3 for each.
All right. Thank you for the enlightening discussion to both our presenters. My question is addressed to Dr. Kamala on deliberative democracy. Okay, my first question is, what is the threshold for public participation? Does the Public Participation Bill of 2019 give a threshold? Because it can be so elusive to try and figure out what public participation really entails if we do not have a threshold being set forth by the various pieces of legislation that we have. My second question, and the last one, is deliberative democracy presupposes a situation where we have people being at par when it comes to the power balance. But as we understand in ADR, even when it comes to negotiations, a challenging factor is there's power imbalance even in such a setup where people are discussing or trying to have consensus. So how do we get rid of the power imbalance, be it economic power, political, or even social, to come up with a favorable deliberative democratic outcome? So those are my questions for Dr. Kamala.
Let's move up. The lady there. We'll come back here.
Okay, thank you so much. My question is also to Dr. Kamala. He's talked about the concept of electoral dictatorship, and then said that there is need to move to the idea of public participation when it comes to the formulation of electoral laws. So my question is this: is it that we just like throwing around the word public participation whenever we are loggerheads about laws that are facing on issues that are affecting members of the public, just as a way of staining the acts of our leaders of imposing their ideologies on us, or because clearly I don't think there is a lot of willingness also on the part of members of the public in actually participating with this. So my question is that, is it that we just fall back to public participation just because it's flowery, or is it plausible to actually use public participation to actually remedy this issue of electoral dictatorship? Thank you so much.
Your name? You didn't say your name? Noel. Okay, there was a there, then we come down here.
Thank you. My name is Kavuda, and my question goes to any of the presenters. So I would just like to know, well, as a future political aspirant, I have read certain articles on the politics of the country and how one can easily influence the voters and be able to emerge as a winner. So I have met very many funny articles, and I'm so shocked because most of them are written by very influential people to the politics of the country. Like I was, for instance, reading an article by Isaac Mwaura, and he was trying to say that for you to be a politician,